started here. Welcome everyone to today's webinar, Sexual Harassment Training Update, presented by Barclay Damon. Many thanks to our presenter, Michael Sciatti, for being with us today and all the participants who have joined in. We'd also like to thank our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. Michael will share his presentation with you, then follow with time for questions and discussion. Please use the chat to submit questions during the presentation, and just a reminder to keep your audio on mute to minimize background noise. With that said, I'll turn things over to Michael to start things off.
Great, thank you. Good morning, everyone, and thanks for having me here again today. I wanted to do this webinar to sort of remind the business community of its ongoing obligation to continue sexual harassment prevention training. We're actually seeing a trend where employers seem to be forgetting about it and not doing it year after year. It is mandatory that it be done every single year, and you need to continue doing it unless the state of New York tells us otherwise. So just a refresher that there's a few things that are new. You may have to tweak your sexual harassment prevention policy because the version the state publishes is actually inaccurate in one area, which we'll talk about. They changed it with a subsequent law. So, we'll go through this today. Again, as always, I put my contact information up here. If you have a question you don't think about until later, just shoot me a quick email in that regard. I'm also on Twitter and LinkedIn. I literally post, dozens of items every week. Twitter, you can simply follow me, and LinkedIn, I let everyone in the network as long as you try not to sell me anything at the end of the day. Why are we doing this? Quite simply, as I indicated, it's a refresher, and because the state of New York requires it. We're going to go over some general harassment concepts, just as, again, as a refresher. Who can harass who? Anyone. It can be internal. With your employees, they can be harassing. It could be a supervisor, non-supervisor. It could be one of your vendors, the FedEx guy, the photocopier repair guy, one of your customers that comes in. We had a bank recently that terminated its relationship with one of its customers. Why? Because he was coming in sexually harassing basically anyone that waited on him, any of the female tellers, and we ended that relationship with him, and he was hopping mad. He thought he could do whatever he wants, and no, you simply can't. We'll also review generally your policy requirements. I'm a fan of adopting the state's model policy. That way, if you're challenged or audited, just say, hey, this is what the state of New York told us to do, but you do have to keep up to date on changes. And the state, I think it's been a little slow to alert you as employers as to changes. The big change that you have to change in your policy is it used to be 1 year for an individual to file a claim for sexual harassment with the Division of Human Rights. Now it's 3 years. And the model policy that the state publishes still says 1. So make sure you make that change in your materials. What is sexual harassment? Again, quid pro quo, 2 types: sleep with me or else, or sleep with me and I'll reward you in that regard. So you have the threat and the reward type sexual harassment. The hostile work environment, it could be touching, staring, leering, watching pornographic videos, suggestive photos, text messaging. It could be all of that or some combination thereof. Retaliation is a legal concept. You have to protect your employees from retaliation. I will tell you what protected activities are in that regard. Please remember you have to review the legal protections with your employees. It's how do you sue the company? You may not like it, but you have to do it. Lastly, the case studies on the New York State Department of Labor's website for sexual harassment. They have a bunch of case studies. If you're doing the training yourself, I would encourage you to use some of those. So again, why are we doing this? We have had many instances of bad actors, from Bill Cosby, who is now suddenly released again and facing a new trial, to Kevin Spacey, to others, which really led to the Me Too movement in New York State reacting and bringing sexual harassment to the forefront. With that, Governor Cuomo latched onto it, passed a law that is ridiculous because almost anything can be sexual harassment. And then it backfired on him. I was just like, I wrote a letter to the state when they passed this law and said, you're out of your mind. As an employment litigator, you're basically making anything sexual harassment. And then you saw him try to backtrack. Well, I didn't sexually harass anyone. I didn't intend it. But if you looked at the law and what the allegations were, there's no question some of it clearly fell into this new law. So for what it's worth, general harassment concepts, please remember to train your supervisors and those of you who are frontline here or HR. How can I help you? Let the employee complain. Let them complain and say whatever they want. Why? Because that gives you information and then you need to react. Remember, you don't need to react in front of your employee. You don't need to tell them you agree or disagree with them. In fact, I would tell you to take the following position. Don't believe them, but don't disbelieve them. That is the purpose of the investigation. They could be telling you the 100% truth, a 100% lie, or maybe a little bit of gray, 50-50. So keep that in mind. How can I help you? That should always be your attitude and your supervisor's attitude. And again, we're seeing, a couple years, 3 years ago, front and center. Now people are forgetting and reverting to their old ways. The concepts and the new law are very simple. They want to stop sexual harassment. They want to give individuals an opportunity to complain by having a written complaint form. All of you should have a written complaint form. It should be either incorporated into your handbook as an appendix or in the policy itself. You want to be able to investigate, and we're not talking about how to investigate today. That's like a 3-hour webinar, believe it or not. And then you have to remediate, figure out who's telling the truth, and then what you're going to do about it. Don't be an ostrich. The ostrich puts their head in the ground. If an employee complains or you learn of sexual harassment, no matter how you learn of it, you must investigate, period. There's no exception to that. Well, the employee doesn't want me to investigate. It doesn't matter. And that is a concept that many employers are having a hard time with. So please remember that. I always, when I do investigations for employers, I always tell the alleged harasser, hey, look, if this is a false claim and it's a total lie, 100% lie, meaning they made it up, which is a very high standard, that's illegal. And that does not protect the employee from retaliation, et cetera. And you're like, well, Mike, how would you find that out? I found it out once. An employee was using a company computer and was using a company instant message program. And we downloaded the instant message program, and her discussion with another employee sort of went like this. The other employee said, I thought he was sexually harassing you. The alleged victim's response on the chat, no, I made that up. Pretty good evidence that the person was lying. Before we could fire her, we confronted her with it, and she in fact quit, and the EEOC dismissed the sexual harassment complaint based on the text message or an instant message we found. So keep that in mind about these false claims. There are other retaliation protections which are legitimate, which I will go through and give you examples of. I would be remiss if I didn't point out there's lots of other forms of harassment. You should have 2 policies, the state sexual harassment prevention and then a policy that allows others to complain about all other forms of discrimination, harassment, retaliation, or protectivity in the workplace. And I've listed some of them up here. Please note that sexual harassment now is its own protected category, and it is a subset of sex-based discrimination. One of the key things I tell you as employers, please follow your policies. I am seeing more and more employers deviate from their policies. And it's like, well, why do you have them? Please follow your policies and be consistent in your enforcement. The policies apply to everyone. Excuse me, there are no exceptions. Even if it's the CEO, you may not be able to do anything about the company owner or something like that, but you still have to follow your policies or attempt to follow your policies. Who can harass who? As I indicated right at the outset, it's anyone. Males can harass males or females. Females can harass females or males. A supervisor can harass a subordinate. You could have coworker harassment. We have even seen a subordinate sexually harass a supervisor. Vendors, customers, and now New York State has flipped it. If your employees are harassing third parties that enter the workplace, that third party can now bring a claim against the company for sexual harassment. The example would be the FedEx delivery guy comes in and every day the receptionist makes sexual comments to him or others do, and what have you. So he could actually bring a claim in that regard. So keep those things in mind. So the policy requirements, one of the things you should have in your policy is an equal employment opportunities statement. You should have a reproductive rights statement, which New York now requires. You should have a diversity statement. Diversity is strength. You want to have a diversified workforce. Some of you can't get it. Some of you it's easy to get. A lot of the times it's based on location, the skills you need for people, etc. I put up here a sample EEO policy. You can sort of modify it as you deem fit. You can list more protected categories if you wish. The company is required under New York State law to maintain basically a zero tolerance, a harassment-free workplace that basically allows people to come to work and work while at work. That is what New York State is striving for. And hopefully things get better in the workplace. I think generally speaking, they have, but in those problem cases where we get brought in, it's pretty consistent. No training. They're not documenting the investigations like they are required to, and they're simply not following their policy. So that's what is getting employers in trouble. If you are not doing one of those things, you got to fix it. If you're doing all of those things, wonderful. If you're doing two of them, you got to do the other one. So just make sure you clean house at the end of the day. The anti-harassment policy, it includes everyone. No one will tolerate harassment from the CEO to the third parties that enter the workplace. Covers covers interns, visitors, contractors, customers, whoever it may be. Zero tolerance. Mike, you're taking all the fun out of work. We can't even joke anymore. Well, if the joke falls within anything that I'm talking about today, yeah, you can't do that anymore. It's just the reality of the world we live in these days. The company encourages employees to report all information relating to harassment and the identity of any alleged harasser or victims. As you will see, a supervisor must report. All other employees are strongly encouraged to report. And it makes sure your reporting structure in your policy is clear. Once you get a complaint, no matter how you learn of it, it doesn't have to be from the employee. You must promptly investigate and take effective remedial action at the end of the day. If your investigation reveals that sexual harassment has occurred, or what is most likely a code of conduct violation has occurred, of course you can discipline that employee. And again, the discipline options, you know, but don't forget the unpaid suspension. I tell people that that hurts. 2 weeks off, no pay. Ouch. And that gets the message across a lot of times. The policy itself that New York State requires you to have basically applies to everyone. It doesn't make a difference whether they're a real employee or just a customer, an intern, or an applicant. It makes no difference whatsoever. The immigration status is not relevant. New York State has taken a very strong stance on this. You know, if you have someone who is, quote, illegal, close quote, and not authorized to work in the US, that's irrelevant. If you know that they're not authorized to work in the US, we have to have another discussion because you're probably committing a felony level offense as an employer in this regard. If President Trump was still in office, your risks of being caught go up dramatically. With President Biden, I don't think not so much. But you know, we'll see in that regard. But we should fix that problem if you have it. Employees have an obligation to cooperate. You can discipline any employee in an investigation that refuses to cooperate. I don't know what you want to do to them. That's a business decision. But if you know, a lot of times I don't want to get involved. That's too bad. We're asking you X, Y, and Z, and we expect you to answer X, Y, and Z. Management employees, as I've indicated, have an absolute obligation to report anything they become aware of or observe. There's no exception. Even if the employee doesn't want them to report it, it makes no difference. Please remember that when you do, I'm a fan of training the supervisors and non-supervisors separately. Those of you that on this chat or webinar that I've done the training for, you realize the message to the supervisors is slightly different. Even though a lot of the slides are the same, the message is different. This is what we want you to do. I don't want to necessarily tell a non-supervisor what a supervisor's obligations are at the end of the day on all issues. They must report even if it's trivial or the individual who doesn't want them to at the end of the day. Supervisor does not do this, they can be disciplined up to and including termination of employment. The obligation of non-managers strongly encourage. You know, we can't help if we don't know, and that is the message I'd like to convey. I gave you two appendices. One is the state's model policy. The other is the state's complaint form. I would modify them, update them as I've indicated to you already, and use those at the end of the day. When you do your training, you convey to your employees basically the following question: what should I do as an employee if I am being harassed? Walk them through that process that is in your sexual harassment prevention policy. You want them to feel at ease. It's okay to complain no matter who the complaint is about. Let's see what else. Behavior does not need to be a violation of law in order to be a policy violation. So is it illegal? The example I always say, is it illegal, assuming the magazine is still around, to go and buy a Playboy magazine and bring it home? No, I don't think Playboy's around anymore, but you know, when it was, that same magazine I bring into the workplace, that should be a policy violation. Why? We don't want Playboy in the workplace. We're here to work, not look at the Playboy magazine. We need to have a written complaint. I always try to get the employee to write the complaint in their own handwriting. If they refuse, it is the obligation of the supervisor to write the complaint. The supervisor that says just ignore it, that's Johnny being Johnny, Mike being Mike, that person needs to be disciplined, probably undergo sexual harassment prevention training again. If I witness sexual harassment, same thing. They need to realize they are protected from retaliation if they bring a complaint for sexual harassment. You must investigate, as I've indicated. The investigation process is sort of outlined in the sexual harassment complaint form. So just take a look at that there. And again, anyone that engages in retaliation, anyone that refuses to cooperate with an investigation, those individuals can be disciplined. Details are set out in your policy. When you look at your policy and complaint form, you will see that the state has outlined like 10 bullet points or something, which a investigation should entail. Doesn't have to in all cases, but should entail. Sexual harassment, again, is its own classification of discrimination here in the state of New York, and is a subset of sex discrimination under both federal and state law. It includes harassment on the basis of one's sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, or the status of being transgender. I defended successfully a gender expression case, and here was the facts. And God's honest truth, the individual identified, expressed himself, perceived his sex differently every day. So he's a biological male. So on Monday, he'd be a biological male. On Tuesday, he believed he was a female. On Wednesday, he was the hybrid. And that's the term, that's his term, not my term. And he had 3 different Facebook pages, one to match each perceived sex, depending on the day. And that's the reality of what we dealt with. And he took the position, you fired me because of that. And our position was, no, you threatened a supervisor. That's why we fired you. And our defense was, on the day you thought you were female, you'd come to work in a dress. And we never said anything for years. And no one cared at the end of the day. But remember, it's a very broad definition here in New York. Non-sexual conduct may be sexual harassment. The example, will you go out with me? No, I won't. I go out and key your car. Yeah, it's a crime. Yeah, keying the car is its own violation. But is it also sexual harassment? Maybe. I did it because you wouldn't go out with me. Is it because of your sex? I think so. So non-sexual conduct may be sexual harassment. Don't dismiss it. Location of the sexual harassment doesn't matter. Could be while you're traveling for business or at an employer-sponsored event. It can be after hours, calls, texts, emails, social media, even if they occur away from the workplace, on personal devices and during non-work times. I'm in the middle of just starting an investigation where there is an off-duty conduct alleged, and everyone is surprised why we are investigating. And then I put up this slide and I explained to them, this is what New York law requires. It doesn't matter where it occurred. If your employees are involved in this, someone has complained, which they have, you're obligated to investigate. 2 types of sexual harassment, as I've already alluded to, nothing new here. Quid pro quo, do this or else, or do this or I will reward you, or the hostile work environment. So the slides that are here, I have put a lot of details of this. Some of them will go fast through, some of them we won't. The federal standard is severe or pervasive to alter the conditions of the work environment. That continues to be the standpoint. It's a totality of the circumstances based on objective and subjective points of view at the end of the day. That is the federal standard. That is what the federal court will provide. New York State's a little different. It doesn't matter whether you meet the severe or pervasive standard. such harassment is unlawful when it subjects an individual to inferior terms, conditions, or privileges of employment. Makes a big difference. Severe or pervasive is up here. Everything else that New York is referring to is below that standard. So that's why this is important. New York State also takes a rather unique view. Doesn't matter if the employee complained, they can still bring a lawsuit and we have to evaluate it. They did away with the Elliger-Farrell affirmative defense. An employee need not, in New York State, say there's a comparator, unlike sex discrimination under federal or state, under federal law. They've taken away the comparator issue. New York State has a reasonable victim standard. Basically, the only way to get out of a hostile work environment case is if a jury finds it's a petty slight or trivial inconvenience. So hypothetically, I flip a female off in the workplace. I give them the middle finger. I tell them, hey, you look hot today. 2 things, that's it. Is that enough to get to trial in New York? Maybe it is. Maybe it is, unless a court or the jury finds it's a petty slight or a trivial inconvenience, and the law did not define that for us. Okay, unwelcome sexual advances constitute sexual harassment when this is the quid pro quo standard. I have summarized it for you already, but I've given you it here a little more in depth and what have you. I don't want to spend a lot of time on that because it's pretty obvious what it is, and I've explained it already. The one you're typically going to get is a hostile work environment complaint. Now, it can be created words, signs, jokes, pranks, or intimidation. It doesn't really matter. It could be physical actions or acts of violence. That's why you have to be on guard that, you know, these actions, you know, could be, let me just go back to the slide. A sign, I could be wearing a t-shirt that is inappropriate. Pranks, a practical joke. The question you always have to ask yourself is, why was the practical joke done? And what have you. It could include pictures, posters, calendars, graffiti, objects, reading material, material that is sexually demeaning or pornographic, displays on computers or cell phones or tablets, sharing displays or other information in the workplace. It could also include interfering with, destroying, or damaging a person's workstation at work, interfering with an employee's ability to do their work, sabotaging an individual's work, bullying, yelling, name calling. All these things are examples of things that may be sexual harassment. The kisser, the hugger, the patting or brushing against someone, repeated lewd, crude, or suggestive jokes or language, asking about someone's sex life, repeated requests for dates. Asking someone out one time is fine, but no means no. And obvious one, a sexual assault in the workplace. In addition, it could be unnecessary touching, comments on physical attributes, displaying sexually suggestive photographs, and using inappropriate terms and epithets, which could include simply swearing, in my opinion. I mentioned the gestures and other things here. Emails, text, Snapchat. Snapchat is one of the most evil devices created for an employment attorney because the photo sometimes disappears. But you know, all those things we have seen others use to harass other individuals. Some nonverbal things can also be sexual harassment. You know, you just, you know, you have cartoons or calendars up, but you don't say anything. Could have something on my clothing or tie or coffee mug, but I don't say anything. winking, blowing kisses, or staring, but I don't say anything, blocking the exit, making sexual gestures with hands or body movements in that regard. I had a doctor once during a surgery do that. All the nurses complained, and it's sort of like, what are you doing? Well, I thought it was funny. You're operating on a person and you're making sexual gestures using the person's leg that you're operating on. He was very close to being terminated. He was severely disciplined, suspended, and things along those lines. Magazines. Now, I have some here that I've collected over the years that people have referred to as, hey, this is what was in the workplace. This is why I was sexually harassed. Flex magazine. It's a bodybuilding magazine, but someone complained and said, hey, look at this. That's a scantily clad woman. I would agree. In 90% of the workplaces, this would be inappropriate. It'd probably be fine at a gym. It probably would be fine at Wegmans, where they sell this magazine, but it wouldn't be fine in most offices. The Sports Illustrated swimsuit edition, constant. We get that all the time. Cosmopolitan. Look at the headlines. All right. Well, it's Cosmo. No, look at the headlines. The number one thing he craves in bed. You can read it at home, but don't bring it into work. Glamour, same thing. Look at the headlines, sex do's and don'ts, and things along those lines. It should not be in the workplace. Again, harassment can also be jokes, cartoons, and cards. Again, I've collected some from over the years that came up in cases and what have you. Everything you need to know about over-the-hill sex. No, it shouldn't be in the workplace. The Iraqi mobile missile launcher. This was from a national origin case, national origin harassment case, but this was plastered in the workplace, all over the place, and it was targeting an Iranian national during the Persian Gulf War, and what have you. He didn't appreciate it and filed a claim. He also had this sign he had to deal with: do you believe in equal rights for whites? And the ultimate Gulf vacation. He put all three of those together and was able to substantiate a national origin discrimination claim. I didn't think this was anything, but someone showed it to me as part of the investigation and claimed it was harassment. The squirrel, someone claimed this was harassment. And you know what? In retrospect, when we did the investigation, yeah, this is part of the thing that we used to find the claim was substantiated. It was more than just the squirrel, but there was a lot of other things as well. The guy on the beach was also part of the squirrel investigation. And again, we said inappropriate, and we ultimately found the employee had engaged in sexual harassment. There were dozens of comments, there was touching, there were emails, there were photographs. So it was pretty serious. This was after 9/11. It was the Osama bin Laden swing set. This came up in a national origin case. A noose, even a photo of a noose, unless there's a business reason for it, is not allowed in the workplace. It is per se discrimination at the end of the day. No matter if you're cheering for Osama bin Laden's death or not, doesn't make a difference. Dress discussions, we have had backfire on employees. Stereotype jokes such as blonde jokes have backfired on employees. So please keep all those things in mind. Now, retaliation, please remember employees have an absolute right to complain about sexual harassment in the workplace, even if they're wrong. As long as the complaint was made in good faith, that's all that matters. They're not lying through their teeth. It's okay to be mistaken, and you want to encourage your employees to complain, even when they're not sure. So let me just, there's a few things here. It could include threats of violence outside of work. You know, the employee complains against a male. The male is at a bar and sees the employee and goes over to him. I hear you complained about me. I should beat you up right here. But he doesn't. That's a threat of violence. That's going to be deemed retaliation. That's probably getting the person who made that comment fired. So what is protected activity? So here is what it means in New York. I am allowed as an employee to make a complaint of sexual harassment internally or externally. There's nothing you can do about it. You can't discipline or fire me for doing so. As an employee, I can testify or assist in a proceeding of sexual harassment under state and federal law, and there's nothing you can do to me. I can oppose sexual harassment by making a verbal or informal complaint to management or simply informing a manager or supervisor that harassment is in fact occurring. I can report that another employee is being sexually harassed. Doesn't have to be me. I get reports of sexual harassment from third parties, a union, the NAACP, other advocacy groups, and we handle and investigate those allegations. I can encourage a fellow employee to report harassment. Again, nothing you can do to me in that regard. If I find out that what the employee complained about doesn't qualify as harassment, I still can't do anything to them. Why? Because of the good faith basis. But if they lied about it, absolutely, I can terminate them. You have to educate your employees on the legal protections. And there's only been a few changes since the law first came out back in 2018. Again, we have the New York State Human Rights Law. It's going to cover everyone on this call. Here's the big change. It used to be you had 1 year to file with the Division of Human Rights. Now you have 3. So you have to go back and probably modify your policy. Your policy probably says you have 1 year to file with the Division of Human Rights. This is an amendment that it came after the sexual harassment training went into effect. It is now 3 years to file with the Division of Human Rights or 3 years to sue in New York State Supreme Court. They can also bring a federal claim, and they have 300 days to file that claim with the EEOC. You have to explain the damages to them, but I always put it in context of the following. It's not lotto. This is not Powerball. This is not Mega Millions. You have to be able to prove as an employee what their damages are. And I've put a bunch of the damages up here under the federal law for you to take a look at. And they basically mirror each other under a state law. When you do your training, put this part last. Why? Because they're tired and they want to get out of there. I don't want to spend a lot of time educating them about the remedies or how to file a complaint, but do it at the end and do it quickly, as long as you cover what you need to cover. Let's see, you can, there's local human rights boards. There's one, I think, down in Ithaca. There's some down in New York City, so that those also exist as well. Okay, so for the last 40 minutes or so, I quickly reviewed, where we are here in New York. What we are running into problems with is employers are forgetting these obligations. The big things they're forgetting: 1, follow their policy; 2, keep the policy up to date. All right. Number 3, any complaint must be investigated and documented under the policy, and you have to do the training. People are forgetting. I want the training documented. I do recommend you rotate trainers. You don't use the same trainer every year. It gets boring. The state of New York has a video up that you can use. That's fine. But I would try to mix it up every year to do something different. Maybe a recorded. For the last couple of years, we've probably been doing webinars or recorded. And then maybe go back to live presentations at some point. But I'm a firm believer, mix up the training. So like I may train for one employer every 3-4 years. That's fine. I think you should have other trainers so they pay attention and hear another message and the point of view. I think that's important. I think one of the things we're going to be confronted with shortly, I don't know if the new governor is going to pick up our old governor's training enhanced law that he wanted. He was going to propose or had proposed additional training requirements. I don't know if our new governor will follow through with that or not, that there be supervisor training on top of the employee training. I think that's a good idea anyways. I would train the supervisors separately, but I think as of now, we're good. I don't think they need to add anything more for you to do or to keep track of. But hopefully this refresher, just go back. The big thing is modify your policy. If you adopted the state's policy, there is, it's the old policy says 1 year to file with the Division of Human Rights. It is now 3, so you have to change that. And with that, Candace, I'm happy to answer any questions that anyone may have, be it in the chat or, you can let them talk.
Thank you, Michael. We can give it a minute here and see if there are any questions that come up here in the chat, or feel free to unmute yourself and ask a question. Again, the webinar is being recorded, and after the link is done, we will share that with everyone here today.
Okay, I gather not. And if you do think of something, just email me in that regard. Hold on, I think we got one. Do you think they'll ever make it so they don't have, it doesn't have to be done every year? But man, I would love that, because the typical reaction we get, Tammy, from the employees is, didn't we just do this? Telling them we have to do it every year. I think they tune us out once they realize it's the same. That's why I like rotating the trainer. No, I don't think they're going to change that. I think that is something that is here to stay. Just like that Wage Theft Prevention Act form, which I think everyone hated at the beginning. We got used to it, and I think we're going to have to get used to this. Is training still required upon hire in New York State? If so, what is the time period from date of hire to the complete training? Okay, so there is no hard and fast rule. I am a fan of recording your last training session and keeping a copy of the materials. You then show that to the new hire immediately on when they start. Day one, they review that video. That is what I believe the best practice is. My recollection is it has to be done within a reasonable period of time, and that the guidance does not state what that is. My position is I will not let an employee work on like the factory floor until they've undergone the sexual harassment prevention training. Just record it and make them watch it on the laptop and have whatever other training you want them to go through before they start working in that regard.
Michael, so if they've had the training at their previous employer and they come to a new employer, do they have to take the training again within a reasonable time frame, or are they covered for their year?
If they can produce proof and the prior training covered everything, I don't know how you're going to know that last part.
Mm-hmm.
Sometimes what we're seeing is little certificates, training certificates. The unions are giving out little cards. Mike's been trained in sexual harassment prevention. He's good through such and such a date. You can accept it and then wait to the next training in that regard. Sometimes employers don't like to. Why? Because their policy is a little different. They may have modified the state's policy sometimes. I'm a fan of training them and just, it's what, an hour. I'd rather feel better and do it. I gather in hours an hour. But you can do either way. You can say that's not, it doesn't matter. We don't accept that. We're making you do our training again, or you can accept it. It's up to you.
Thank you.
Anything else? Okay. Well, again, if you think of something, just shoot me an email. We're going to have, Candace and I were talking, we have a couple other webinars in the works, and we'll get those posted fairly quickly. So thank you, everyone. Hold on, one more question popped up. Where can we find other training videos? The only free one that I'm aware of is the state of New York on their website for sexual harassment, but that's it. Other ones you have to pay for. There you go. And that's where it is. Sorry, you had a frog in my throat, but the link Nicole just sent around to everyone is where they have the free videos. And you may find others. And let me just say one thing about training videos. There are lots of companies out there that purport to say this is in compliance with law. And then I watch the video and it's in compliance with federal law, but it's not in compliance with state law. So just be leery of purchasing videos off the internet or something, because it may not be New York State specific. If it's New York State specific, I'm good with it. I've reviewed several videos that others have showed me, and I said, yeah, that is acceptable. So good to go.
And a reminder to everyone as well that the Chamber, in partnership with the Business Council of New York State, offers an online sexual harassment training, and there is a discount code that you can enter. So the cost is $31.37 per employee. So I can also include the information on that when we have the link for this recording, if anyone needs it.
One other question popped up, and Tammy, I think I understand your question. How are we supposed to know? I think, how are you supposed to know whether the video is in compliance with New York law? We got to watch it. I don't accept their certification. I watch it, and then I tell the client yes or no, or maybe you as an HR person watch it and make sure it covers all the things. The big thing to watch out for is the New York standard and explaining retaliation and explaining the legal remedies. Those are three things that I typically see in non-compliant videos that they don't do. Yeah, I mean, and the other thing, Tammy, there's nothing wrong with every year using the state's video, nothing whatsoever. But you just get employees bored and they tune out. So it's just, some of you approach this, and there's nothing wrong with it. It's to check the box. We got to do it every year. We don't necessarily care if it's the same trainer or the same video. That's fine. And some of you do care because you want them to hear that extra point of view or the different point of view. Both scenarios work. Okay, well, I don't see anything else. Again, if you do think of something, shoot me an email and we'll go from there. I wish you all a great day and have a great weekend, and we'll see you again real soon. Take care, everyone.
Thank you. Thanks, Michael. Thanks, everyone, for joining us, and have a great day.